Good evening, everyone, and thank you for joining us. As promised, as you know, and we said this several times, we try to have an informational session every fourth Thursday of each month. Now, we know Thanksgiving is going to be the fourth Thursday, so what we decided to do is have this one a week before. So, with that being said, we're going to talk about understanding the law. We're going to talk about the landmark Supreme Court case, Endrews F versus the Douglas County School District. I have with me my special education ambassador, Lisa Wilson. And of course, you guys know, I mean, her knowledge is out of this world. I appreciate her being a part of the advocacy team. It is Lisa, but it's of course she's humble, and that's all of us. But I would like for her to start us out and just kind of tell us what this case is all about.
Thank you, Paula. It's a pleasure to be here as usual. I'm just a mommy who is on the special education journey, but happy to share. I just think we often talk a lot about IDEA. We talk about Title II of the American with Disabilities Act. We talk about Section 504 of the 1973 Rehabilitation Act. But I think it's important, and we use the word Endrews, but I think it's important today that we give parents a little context about this landmark decision that you announced at the outset. This, for me, on a personal level, I see this as being just wonderful legislation to, reshape the landscape of special education. However, the reality of it is, from my personal perspective, this is my views do not represent advocacy. My personal perspective is that there is a resistance to this legislation by the school districts because the justices in this unanimous decision, and there were 8 justices at the time, but there was a unanimous decision. One of the cornerstones of this legislation is parental input. And so for me, Paula, what I see the resistance in the school districts is that they really are slow to respond to this legislation because it almost demands that parents have meaningful engagement and be involved in the process. And historically, Paula, and you know this from your beginning, your journey, same was for me, typically the schools control the entire process. They control when the meetings are held, how the meetings are held, what information is going to be discussed at the meetings. Because when you initiate special education services with your child in kindergarten, or if you do the early programs, it's escaping me, child find. If you do child find, you don't know anything about special education. You just know that you've been directed to this office because your child has a diagnosis, and they pretty much take over from there, and you go along for the ride. And so that's typically everyone's experience. And although they give you the parent safeguards, the parental safeguards, they give you that booklet, which is, I have issues with that. It's typed in a very small font, and it's a lot of information just really pushed together.
Legal jargon.
Very few parents actually read it.
Yeah.
And very few parents are able to interpret its application for their individual situations. So the school, you go into this process without really understanding what your fundamental rights are and how to advocate for your child. Mm-hmm. And so I think that this Supreme Court decision is important because it reaches back and it pulls all of the historical cases together, and it changed the standard for the analysis of faith. Mm-hmm. And so and Paula, I love to use you as an example, but
go ahead.
In all honesty, when you began this process, did you even know what an IEP was?
I didn't. So I didn't even. I'm gonna be honest. When you have it where your child goes to there are certain categories of kids that could go to preschool. And I've always heard that because with Jeremy, he wasn't able to go. So when they kept telling me, hey, Morgan is eligible for preschool again, this entire process was foreign to me. Even if I'm gonna be honest, even if the people at infant toddlers had told me, it probably would have been foreign because at the time I'm trying to deal with the disabilities, the appointments, getting to know her. So when you're trying to connect the dots as far as the school and the IEP, it was all foreign to me, all foreign.
Exactly. And I
Mhm.
happen to believe that schools have a responsibility to empower and educate parents on how to advocate for their children. Now
Mhm.
we have what you would call parent support centers, and I know that when I started in our school district, there were three people in there, I want to believe. And keeping in mind, we're like the 17th largest school district in the nation,
Mm.
approximately 135,000 children, and you have three people employed in the parent support system center. And then there are about 17,000 disabled children, which would be their target population. Now, they have since expanded, and I believe there's now five. Don't hold me to it, but I'm trying to give you that number in juxtaposition to how many children are in special education or receive special education services. And
Mhm.
so if the parents don't know, and the parent support center is a static, neutral and objective office within the school system, they don't reach out to you, you reach out to them.
And most
And
likely
so
you get put on a wait list, or you're addressed at their earliest convenience with no fault of theirs, because I'm sure that they would love to have more people employed. But you're right, it just sometimes with all that's going on, it may even fall off your radar to reach back out and follow, because I have a list of, I got to follow up with this person, I got to follow up, but sometimes that list grows by the day.
exactly. So I think
Mhm.
that, personally, my personal recommendation, if we have any superintendents or educational leaders listening, I think that they need to utilize parents such as
Mhm.
myself, such as you, to build a cadre of
Mhm.
volunteer
That would be
advocates
nice.
to wrap their arms around parents as they're entering this process and this system. Because learning how to advocate is a powerful tool because you don't have to stumble so much as you get down the road.
Yeah.
Things become much clearer. Parents understand what their rights and responsibilities are. The teams understand the role of the parents, and then things can move forward in a fluid fashion. So, what I will tell you is that in this case, and we're going to talk about how the state denied the parents' claim, the district court, and the appellate court, which is how the case was able to move. They were able to apply and they were granted cert at the Supreme Court. But a lot of this was based on historical legislation, and that's the Rowley case, and that's Rowley. And that case is significant because that case originally set the standard for faith. So Riley pretty much said, and I'll give you just a little snippet about what
Mhm.
Riley was about, because I think
Mhm.
sometimes we get caught up in the legal jargon, and we kind of need just a little bit of glimpse
We
inside the
need
case.
layman's terms. Yeah, we want to break.
So Riley was a student that was hearing impaired, and while she was getting support, the parents believed that she needed sign language, and the school
Mhm.
district didn't agree. So, of course, the case matriculated through the court system. And so the standard was established that schools have to create a reasonably calculated IEP to enable a child to obtain educational benefit. But I want to tell you something unique about Rowley. She was doing well, she was performing at grade level. So that means she was not, the court interpreted as since she's on grade level, that she was not being denied faith. Okay. But what
Now
Riley
let's break
didn't
up
do,
faith again. Let's when we're saying it, let's
yes,
kind of say what that means. Lisa, I'm sorry.
That's an acronym, FAPE, for free appropriate public education.
Mm-hmm.
So the court said, well, no, she's performing at grade level, so she's not being denied FAPE. This is now I'm going to take you to why we're here today. What Raleigh didn't capture, and so school districts, so as you can see, there was no real standard. It was okay, well, they're getting educational benefit, but they really didn't define what that was. So the school districts did the minimum in most cases, and that's de minimis. But what this case didn't capture, and this was in 1982, so that's the 35-year difference until we get to the 2017 decision, to show you how special education has fallen off a cliff into a deficit.
Mm.
What it didn't capture is that it didn't capture students who were not performing at grade level, which is how we ended up at Endrews with Endrews.
Okay.
And that will be applicable to my son because my son has had an IEP, he's had services, but he hasn't made academic progress, and he certainly isn't performing at grade level. So the Supreme Court, in my mind, they granted cert because they recognized that it didn't capture the children who were performing below grade level. And they wanted to come in and reestablish the standard and then put more definition and more instructions to the schools about how these children have to be educated. And so essentially, this case changed the standard of analysis for FAPE. So most importantly, the focus is on the child's individual circumstances. That's huge, Paula. That's huge.
Mm-hmm.
And for me, I'll give you a real-time example right now. What's happening in my school district is that they have pivoted to virtual speech.
Mm-hmm.
And children have small groups and they're brought into a room, and there's a facilitator physically in the room, but the provider, the speech pathologist, is delivering the service virtually from a location likely to be in another state, because this is kind of what's happening now. They're piping in providers from other states or from a central office in the school district.
Mm-hmm.
In my hometown where I'm from, they have a shortage of school teachers, Paula, and they have now pivoted to almost all virtual teaching.
Really?
So, yeah, I read it in the newspaper and it was quite shocking.
And that
Quite
includes
shocking.
the special education as well?
I'm not certain. The article didn't drill down in it, but for me, I was suspicious about that. And then even the children who haven't been identified, who are kind of caught up in that general population. And so the individual circumstances, the unique circumstances, the unique characteristics to your child, this is what the Supreme Court brought forward, is that, no, we have to do this on an individual level. And so the reason that I'm concerned about this pivot to virtual speech and you bring a small group in is because, say you have 3 children sitting before the television or whatever, however they're piping it in, they all have different needs.
That's
they
right.
all have individual, unique circumstances.
So they have
this
that
is
one
why we
teacher
need
teaching all of those individuals that have different needs. They have that one teacher virtually teaching all of that's nonsense.
And so understanding that if your child has receptive expressive, your child has stuttering, your child has another communication language, like, it's impossible for their individual needs to be met. And so let's say it's just one child in front of the TV screen, but have you examined to determine in the IEP, with the IEP team, consent and consultation, if that is the best method of delivery for that child?
And see, for my daughter, it wouldn't be. It wouldn't. And I
And for
will say Yeah, during the pandemic, Morgan, it was no way she would not do it. So even if they had set that up with that in mind for her, she would not be able to learn like that.
Exactly. And so this is why this legislation is so important. And you hear me use this Endrews. And what I want parents to be able to do, Paula, is learn how to use this legislation in their communication with their IEP teams. Because what it does is it tells them that you understand what the standard is. And so the standard is that the individual circumstances must be considered. And so now, um, one perspective is that when they talk about individual circumstances, that's tethered to the child's diagnostic history, not necessarily the disability, not
Mhm.
necessarily the disability. Because what's important, remember, the key words in special education is the child accessing the curriculum,
Mm,
accessing their education. So it's about understanding the adverse impact of the disability that is actually contributing to the educational deficit.
mm.
So, case in point, all children with autism, some may not be in need of an IEP because some are very high functioning. But then
Yeah.
you may have another child, like my son, who has executive functioning
It's
deficit.
not-
So
Yeah.
his organization, his planning, so he needs that. He needs, not only does he need an IEP for his academic piece, he has a special direct support aid. He has other related services to support him. And so, what's important, and this is another thing I'm really excited about talking about this, because a lot of times when it comes to the IEP, there is a hyper focus on the academic piece, but there are other areas. There are functional areas. They're social emotional. They're
Hmm.
living and life skills, functional and independent living, communication and executive functioning, organization. These are just a few things that really the team should be considering collectively. But there
Hmm.
tends to be a hyper focus on reading, writing, math. And okay, maybe they need a little
I
speech.
agree.
But like my child has, and most kids with autism, and I'm just using autism, not that it's the only disability, they struggle with that social emotional and
I
that
agree.
communication piece, reading
Hmm.
social cues. So it's important when you're working with the IEP team to develop the goals that you make sure you consider goals for social emotional deficit. And so executive functioning, organization and planning. And so that's something that I really haven't really zeroed in on my son's IEP because he has a direct support aid.
Hmm.
But going forward, as he gets older, I want him to start advocating for himself and I want him to start becoming more organized. And so
Hmm.
I'm going to introduce something to his new team when he gets to his new school. We're in transition.
Hmm.
And so I've already went into Chat GPT and created this little checklist for him to be able to kind of work on his organization. But I'm going to want that adopted into the IEP by the IEP team, so that'll be a goal. So he can learn how to really focus on his organization. He has a direct support aid. We don't want the aid to take away the independence, but we have to pivot and figure out how to promote more independence when it comes to organization and things like that. And so that's something I just really want people, I really want to stretch minds with this conversation, Paula, because it's so important that you understand what your power is. And so,
Hmm.
you know what we're going to talk about, the importance of advocacy.
Yes.
Because this legislation, what it did is it talked about three important things. One, the progress. They have to be able to make meaningful progress. De minimis is no more. The goals must be ambitious, and we've talked about that with your child. The goals must be ambitious. If they're going to move forward, we can't, the status quo is no more, de minimis is no more. They need goals that are going to really push them into progress. And
Hmm.
then it talked about knowing the potential of the child to understand the goal, to understand how to create meaningful goals. So you have to know the potential because,
Right.
again, go back to that individual circumstances. They're all individual. And then three is the parental input. That is, it's already recognized by IDEA, but now we have the Supreme Court reinforcing the fact that our role in this process is monumental. We are not bystanders. We
Mhm.
are legitimate and bona fide IEP team members. And we should be able, as a subject matter expert for our child, we should be able to play a meaningful role in the IEP team. And then we should be able to exchange information, and then we should get a response. Most
Mhm.
of the way we get our responses through the PWN, which is the prior written notice, which is issued after the IEP meeting. But the most important thing is that parent role. So I just want to, I'm going to pause there, Paula, because I really want you to jump in and I really want you to talk about advocacy, and which is really rooted in the whole purpose of advocacy, of why we're doing this. This
Mhm.
is not to fight the school districts. This is
No.
to empower parents to understand what their role is and their parental responsibilities in this
Mhm.
process.
I agree. And I, even as you were talking, I was really trying to, of course, like you say, I don't want to use me as an example, but I have to be the example because this is the reason why advocacy was starting. So I don't mind telling my story. When you were talking about the parental portion, I was never ever told um that the parental part played a role. I was never even, I mean, people were cordial, people were nice, but there was no parental. I was never told, hey, Paula, tell us about Morgan. Hey, help us understand Morgan. Hey, what do you want her to work on? I was never told those things. I was sat at the table. I was never I was never told that you can't sit at the table. They gave me a seat at the table, but
Mhm.
me being at the table and me being a part of the team, I think is totally different. And looking back, I don't think I was ever a part of the team. I think that I was at the table, but I really did not have a full understanding of my role. And so, with that being said, as a result, there was so many things that I was like, well, I didn't want that. And no, I really wanted to do this. So I really wanted to ask this question and ask that question. But I won't say I felt intimidated. I just felt as though, as a parent, before you start asking questions, you need to
Mhm.
sit and listen and understand the process. But it was so over my head that I never really fully understood the process. And I'm not going to say that that was their goal, but in some ways, I think it was because the less I knew, the better off, the school was. And
Mhm.
even when you say that, we're not trying to take over. And I don't think that, I want to be a part of the team, but I want to have an effective IEP for my daughter. And I think my whole goal now is I want an effective IEP, but I also want a great team. Like I love even our team for advocacy. We could
Mhm.
not be effective and help other parents if we did not work together as a team.
Right.
And everybody on the team come with skill sets. Everybody, like,
Mhm.
believe it or not, guys, you think I have it together. I don't. I need the team. If I tried to do this by myself, I couldn't do it. So I relate that to the IEP team for my daughter. When they have everybody at the table, everybody comes with everybody comes as a subject matter expert in their own individual areas. Now, having me at the table, I'm a subject matter expert for Morgan. So now, if we got the speech person here, if we have the physical therapist person, the occupational, now let's take your book knowledge and let me take my knowledge of Morgan and let's put it together and come up with an effective IEP. Do I feel like that has happened? No. And Morgan is 21. Morgan goes to school and Right now, I'm at a place where, guys, just me being having guests on my show, it has taught me that her IEP still has not been effective. So
Yeah.
I am in the trenches right now of fighting the school for what I feel as though Morgan did not get. So
Mhm.
you will see on our website, it's going to be called Morgan's Corner. And what I'm going
Mhm.
to do is I'm going to map it out to tell you exactly what I've done. So I say this to say, as always, I want to be transparent. And I want you to know that what I'm advising you to do, I'm having to do myself. I'm not telling you about the services that I'm finding. I'm not telling you about the IEP processes that I'm going to. I'm not telling you of the schools I'm going. I'm not telling you anything that I haven't done or I'm not doing right now. So with our website and with Morgan's Corner, you're going to see exactly what I'm doing. And I want you to
Mhm.
understand that what I'm doing is not for me to become confrontational with the school.
No,
I
no.
love Morgan's team. I love her. I love her school. But it's a difference between me being respectful and being professional and being um nice to people versus me also becoming an advocate for Morgan. So I will speak to you. We will laugh and talk, but understand my role is to be an advocate for Morgan. So I want you parents to understand that you don't have to go in there kicking over tables and using profanity and doing things that
Never.
that you, because I'm gonna say this, at some point you want these people to try to work with you, and that's ultimately the goal. So I will say that in being an advocate for Morgan, I am an advocate, but I'm
Mhm.
also professional. I'm also courteous. I'm also nice. I'm also, I'm just trying to do what's best for my daughter. So being as transparent as possible, I'm telling you that I'm still learning. I'm still, and Morgan's 21, she's about to come out of school, but I don't want other parents to go through what I'm going through. If I had it to do all over again with the knowledge base that I have now, I feel like Morgan would have made significant process, but we are almost taking and bearing our cross so that other people don't have to. So please listen to
Exactly.
this information. Reach out to us if you have any issues. Let us help you through this process because it is kind of a difficult process, but I think once you get it down, you will
Mhm.
understand, and then it'll help you to pass on the torch and help other people.
That's beautiful, Paula. For me, I have to just add that I come here every fourth Thursday from a place of personal pain,
Yeah.
and I just feel that had I been a little bit more focused early on, understanding that, like you said, when you first, and I'm not certain when you learned of your child's disability,
When she
and
was
that's what I'm
born,
hoping.
her
Right.
disability is not invisible, so it's definitely visible.
Right. And that's why I'm hoping that we can have a show where we can really talk about what happened when we all got the diagnosis, because all
That
of
would
our
be awesome.
journeys began differently. But it's understanding that it's so overwhelming when you first get that information
Yeah,
that you really don't really even have time to pack on anything else, like learning about the IEP process,
you don't.
because you are so overwhelmed with understanding that my life is forever changed. It's
That's
not
right.
negative, but it's forever changed. And so I can't see anyone intentionally wanting to exploit or take advantage of a parent who's in an inferior situation because of their walking into this new journey of disability. So I don't want to believe that IEP teams are inherently nefarious.
Mhm.
But what I do believe that there are very few teachers who have heard the terms Andrew F. versus Douglas County School District. Because in their mindset, what I see is they're still operating under the Rowley decision,
Mhm.
which didn't have a lot of standards. It was educational benefit.
Mhm.
So they're still operating in that mindset. And so advocacy's job is to try to keep pushing and pushing and pushing until we can really bring Endrew forward into the conversation,
Mhm.
because that standard is no more. The Chief Justice of the United States, Chief Justice Roberts, said de minimis is no more. And so we need to have the school districts catch up with this legislation because it's there. And so I said, and I just wrote down while you were talking, I don't believe teachers receive this kind of training. And it's not that you have to go to law school or they're trying to put something, make your job difficult. But to me, as an educational practitioner and as a special education practitioner, I want to know the legal rulings and the landmark legislation that controls and impacts my everyday job.
Mhm.
So when Lisa Wilson comes to the IEP team and states, my son has a vision condition and he needs a larger computer device, he needs a 17.3-inch screen because to mitigate the limitations of his vision condition, that I'm not thinking that here's Lisa Wilson trying to ask for something. Here she comes again. Okay, well, why does he need a device that big? When you understand that the court says the child's individual circumstances, I understand that the school has only one size device that they issue. But when you look at the law, it says the individual circumstances. And
Mhm.
so I think if teachers understood this legal framework, they would be more willing and understanding to sit down and work with parents and see parents as equal partners.
Mhm.
Um, that's just my personal thing. And Paula, what I want to go back to, parental input. A part of that parental input is that parent statement. And we've talked about that when Keisha was on before. That
Mhm.
parent statement is so important. I just had an IEP meeting yesterday and I took about 10 minutes and read my parent statement. I read it. And so that's, and I also want to encourage you to do that too, because I know you all have IEP meetings. Just sit down. And if you can't write a paragraph or you can't type it, put bullet points on the paper so that you can have your thoughts collected as you present to the team. And you want to talk about that, what you see at home. You want to talk about the data you have. You want to talk about your interpretation of the data that they're presenting to you. And then you want to give the background characteristics on your child,
Mhm.
things that they may not know and understand. So that's important. And I just want to add, so in my parent statement this week, I educated them about my son's vision condition, accommodative esotropia,
Mhm.
because there's a myth that when most people see children with glasses, they presume and there's an assumption that the child can see with the glasses. But my
Wow.
son's condition, he can see, but his vision is still doubled and
Mhm.
blurred with the glasses. And so you
Wow.
can see that's totally different than seeing a child with glasses thinking, oh, he can read. Even
Mhm.
the vision specialist in the meeting said, no, I sat next to him. He was reading from the board, but you don't understand it's more than that. His condition causes vision disturbance and visual fatigue and visual strain.
So he
So
does a lot to try to what she's seeing is him working extra hard to try to meet everybody's standards.
yes, you saw him sit in his seat and read the board, but you don't understand what it's taking for him to be able to do that. And I
Mhm.
need you to appreciate
Mhm.
his disability. So I really want to encourage you to do that parent statement and read it. And so when you request your IEP meeting, you want to request it. You let them know who you want to bring with you. You tell them that I like the meeting to be recorded, and then you tell them that I like to open the meeting with my parent statement. And so there's no, ambiguity about what's going to happen at the beginning of the meeting. And so
Mhm.
I just want to take this opportunity because it's my hope that maybe Andrew and his family can see this. I don't know if they keep track of, all the discussions surrounding, their landmark Supreme Court decision, but, I'm excited. I really romanticized this case as I But I just want to tell you a little bit about Andrew. I don't want to present this case anymore without talking about him. He was a child with autism. He was facing unique learning challenges requiring a specialized education support, which we know is his IEP, the Individualized Educational Program. The school districts, they aimed to support his learning, but it was insufficient for meaningful educational progress. And so even if parents can't remember all of this fancy language that we're talking about, remember the goals should be changing, the goals should be ambition, and your child should make meaningful educational progress. If you don't remember anything else we say tonight. And so concerns arose about the adequacy of his IEP and the way it was being implemented. And the goals weren't changing. So in the third grade, the goals were kind of the same. The fourth grade, and then the parents decided that they were going to pull him out of the public educational system and place him in a private educational institution that was able to meet his needs. The first thing that institution did is that they designed and implemented strategies to help mitigate his behavior and to give him an opportunity to really make meaningful progress. And so I'm happy to state and support that Andrew blossomed, he thrived, and he made meaningful academic progress. So the parents went back to the school district and shared the strategies, the implementation, the goals. And the school district kind of said, well, yeah, thank you, but we got this. I'm using my
Yeah,
words.
yeah.
They pretty much kind of blew them off. Well, we're going to keep what we have and we believe. But clearly their IEP wasn't working. He hadn't made progress in 3 years, a number of years. The goals weren't changing. They take him out and then reset and change the way they approach his learning and help mitigate the behavior that was interfering with the learning. And he thrived. He made it. And so the parents said, well, I want to be reimbursed because under IDEA, you can request reimbursement. So the parents said, well, we want to be reimbursed because we have just proven that IEP was insufficient and inadequate. And the school district denied their claim for reimbursement. They went to the state agreed and denied the claim. They went to the federal district court. The federal district court sided with the school district. Why? Because of the Rowley decision. So you see how all of this, it all kind of wraps around and it's all interconnected. And the manifestation that we see at the school level is that we just see kind of the same thing over and over and over and over. It's like rinse and repeat. That's
But
what we see.
but Lisa,
Parents.
let me ask you, why would they line it up with the Raleigh decision? Because she was on grade level, he wasn't, correct? So how can they intertwine the two? Yeah.
But that was the standard of analysis for FAPE. That
Mhm.
was for 32 or 33 years. That was the standard. And so when you look back, and it grieves me, when you look back and you think about for 32, 33 years, all the children that pretty much fell through the system because Raleigh was not a perfect decision
It
and
was
it
not a
wasn't
one size
applicable.
fits all. It's almost like that was just a one size fits all case. It did not apply to every case that came through. Okay.
And
So
I
they almost
think that
like that's that precedence, almost like, but it did not apply to all. Okay. Yeah, that didn't.
And so think about all the families that didn't get what they needed. They didn't. That's 32, 33 years of, really a misapplication of a legal decision. So I was saying she went to federal court. They agreed with the school district. She appealed it in the 10th Circuit. The 10th Circuit appellate court agreed with the lower court's decision, which was the district court. And so at that point, the family was able to apply to the Supreme Court for cert for their case to be heard. And I don't know if you know, but I think that there are about 50,000 applications for cases that are presented to the Supreme Court
I
each
didn't
year.
know that.
I think they hear about 120.
Hmm.
Like, so to be granted cert, and it's a Latin word, certiorari, to be granted cert is a big deal.
It
It's a
is.
huge deal. But I
Mhm.
think what the court realized is what we said early on, is that they didn't consider the population of children that weren't performing at grade level.
Mhm.
And so the court said, no, we need to go back and look at this. And then that's where we get that de minimis is no more. We get the children those goals must be ambitious. They must make meaningful progress. It's not negotiable. And then parental input. And so that's kind of how we, arrived here. And I just wanted to give a little background on Endrew, because he's more than just a name. He is a child who had wonderful parents that went the distance to help get him what he
Mhm.
needed. So that's how we, initially, that's just a little background on the Andrews case. So again, the family felt that the existing IEP was insufficient, and they demanded, for meaningful progress. And so the family really tried, and they did everything they could to get to bring the IEP along with the IEP team along with them. But of course, they kind of were entrenched in their position,
But
even after having the data from the private school and the strategies that helped him to thrive and become successful.
I applaud them parents, because after you get that many doors slammed in your face, but you see, that's how I am. It's like, I don't know. Maybe I can be unreasonable sometimes, but I'm just like, when you argue a case, and it's like, for me, I have always been like that. Some things you don't have, it's just common sense. So for me, I applaud those parents, because as many times as they got the door slammed in their face, they would not stop. I applaud that. I applaud
But I
them.
think, Paula, I think there's also something else we need to recognize that's at play, that school districts have an advantage on, because the average parent doesn't have the resources to engage in litigation to this level and degree.
They don't.
And
And I
so
Yeah, I
in,
do
in
know
Maryland,
that can be a deterrent right there, because most parents know that it's going to be a fight. On top of the already fights they have, maybe from a medical standpoint and everything, and so sometimes they're just tired. I know I
exactly.
was.
And if you have a child with complex medical disabilities
Yeah.
like mine, where you're paying, at one point I was paying 4 uh, co-pays a week, $35 to different behaviors, speech, occupational, physical, a week. So as a parent, and again, we're happy in Maryland. We have our wonderful State Senator Alonzo Washington. He's going to be introducing the burden of proof bill again, which will shift the dynamics in the legal part of it. And
Hmm.
it'll shift the liability back to the school. But the average parent doesn't have the resources that the Andrew F. family had. And so you can see why this is so, like, why I'm so serious about my advocacy, because people don't have the money. Many people are in what you consider medical bankruptcy.
Yeah.
They're trying to pay medical bills. If you have a child with a complex situation where they're in and out of the hospital, I mean, families of disabled children are under tremendous stress and pressure,
Yeah.
tremendous, even before we get to the schoolhouse.
Yeah. You're right.
And so this is why I believe parents need advocacy. We need groups and community organizations, that are willing to empower parents, at no cost. There are some situations where there may be some cost, but for the most part, what we're doing at the grassroots level, Paula, and this is why I refuse to accept a dollar there. I mean,
No.
and even you offered me to pay me. I'm not taking money from
Mm-mm.
anybody to help them with special education. I know what this life is. I know what this journey is.
Yeah,
And
it's hard.
I will never try to impose any further pressures on a family that's grappling with caring for a child with special needs. In the future, if my life changes and things change for me, I'll consider it. But right now, no, I enjoy what I do. I enjoy doing that. I enjoy. So again, the lower courts, they applied the minimal educational benefit standard. I'm sorry. I apologize. Under
Mhm.
Rowley, the family appeal. That's how we arrived there. So now we're going to talk about the legal questions that were addressed. That educational benefit standard. The Supreme Court considered the required level of educational benefit under IDEA for students. Excuse me. Pardon me.
It's okay.
Pardon me. I'm dealing with some allergies and some.
Aren't we all? That's why I had my water.
Yes, I
Mhm.
apologize. But they considered that educational benefit standard. And then the court, um, they evaluated if the IEP plans meet the unique, and that's that word again, unique individual circumstances of a child. And we know what they decided. They found that Raleigh was insufficient because it just didn't consider those unique characteristics of the children. So we had a unanimous decision. I get so excited about that. In this current political environment, we know that it's very difficult for our Supreme Court to agree unanimously on
Mhm.
a lot of important things that are happening right now.
Mhm.
People tend to dig in on their side of the fence, red versus blue, Republican, conservative versus Democratic. But here, the court sent a resounding message to the nation. This was a unanimous decision.
Mhm.
And they emphasize stronger educational standards for children with disabilities. And so that's where we get the meaningful educational progress. And you hear me say that all the time. And I want parents to use that meaningful educational progress when you're talking and communicating with your IEP team. Say, I just don't see where my child is making meaningful educational progress. Can you tell me why? Can we
Mhm.
look at the data? Can we compare? Can we look at the comparative data? And let's really see, is the child making progress? Are they making a little bit of progress? Are they making, a nominal amount of progress? But you have to engage for those conversations.
Mhm.
I know we're almost at the end.
This is very interesting.
Yeah, so if you could just talk about for a few moments, just to give me a moment to gather myself, but if you could talk about the importance of having meaningful, ambitious goals that
Mhm.
directly connects to meaningful educational progress.
Yes. Well, one thing that I would say again, using Morgan, is um, there are some people, and again, that may feel as though because your child is nonverbal or because your child has multiple disabilities, without
Mhm.
saying it, they kind of set their goals up as if they won't accomplish anything. Like as if to say, well, we're doing something, but don't expect a miracle almost. And I think in some ways they do set it up like that. Um,
Mm-hmm.
but for me, that was one of the things that um made me, get Morgan out of the school because it's almost as if the goal she was making, I mean, the strides that she was making, number one, it was not strides that I saw. So the
Mm-hmm.
data did not support it. That's first and foremost. That data is very, very important. And I will say this, guys, even when they said that she accomplished something, I challenged it. I brought her home and I said, let me see it. And I taped it at home. And I did not see it because if she did it for them, I know she'll do it for me. Um, that's one thing. You have to definitely make sure. And again, don't take this as you being confrontational with the school because we did have a couple on last week, and he says we work directly with the school. We have no problems. With the mom was like, "Well, Paula, I'm like you." The father was like, "No, I work with him." So listen, we both agree that the goal is still the same for our special needs individuals to reach their goal and for us to continue to challenge them. So I will say that, you definitely have to check those goals out. You have to make sure that they are goals that will continue to challenge your individual because you don't want them to stay at a level where they don't learn anything. Again, I see where Morgan started and where she is. Morgan is very intelligent. She just learns differently. So her goals should be customized for her and I should see improvement. I should see her reaching those goals. And I shouldn't just see it where they're saying, hey, she reached that goal. Oh, she accomplished that. And I don't see it. So that's what I would tell parents. If you don't see it, ask the school, can you show me how she's doing this or how they're doing this because I don't see it. If they did it once, they should be able to do it twice. If they did it twice, they should be able to do it three times. And
Yes.
at that point, again, where that parent involvement is important, come to the table and say, hey, I don't think this goal is challenging my child,
Mm-hmm.
as much as I would like. And I will say for Morgan, one thing that I challenged was they said that she could identify the name, the alphabet of her name. She could identify the spelling. And when I asked them that, I said, okay, great. That's when I didn't really know anything, but I knew enough to say when they said it the next year, they had that same goal. And I said, wait a minute. And I'm gonna tell y'all that's what started making me challenge them. I said, wait a minute, I think she already did that. They was like, no, she didn't. I said, yes, she did. Because I was so excited. I was so excited. So I was like, yeah, she did. And they was like, no, she didn't. I said, she did. So what they
Mm-hmm.
did was they started scrambling and went back and they came back and said, you were right. She
Mm-hmm.
did. Right
Yes.
then and there, my antennas went up and I started challenging a lot of the things that they were saying she did. So again, for me, you know, even as far as Morgan's speech board, they did not involve me with her speech board. Those are things that, again, my parent involvement would really have been important. So
Mm-hmm.
I just, again, you have to make sure your child is being challenged. You have to make sure the data that is being presented to you saying that your child accomplished these goals is something that is true. So I will definitely, I don't know if that's where you wanted me to go with that, Lisa, but
I appreciate that. That gave me an opportunity to just get my breath. But that's great, and I'm glad that you gave an example. I was going to give an example, but you did a great. That was a great job giving an example, so parents can understand where to look on the IEP for the goals and to see what the expectation is. Because a lot of times they'll say one out of 3 out of 4 tries.
yeah.
By the next quarter or whatever by 3 months he should be able to do this 3 out of 4 times. But in my case, one of the things that really contributed to the deficit that my child is in, Paula, is that he didn't even have a math goal in the second grade. And I miss that because remember, I'm just learning the process. He didn't even have a math goal. And so math is very critical. And, he's nearly 3 grade levels below now.
So
because
when did you see that, Lisa? When did you understand that he didn't have a math goal?
when I decided to file the complaint and I went back and looked at the IEP, and then I was, working with some other people to look at his IEP a little bit more critically. And it was like, wait, where's the math goal? It wasn't there. So he went an
Mm,
entire school year without a math goal. And so
wow.
that's that. He already was operating at a deficit. That only just really, and second grade is a very foundational year.
But I think it's good that parents hear this because they think that they see us where we are now and they think that we didn't make the mistakes. And we did. This is why advocates say it started. This is why we're so vocal about these things because you think we have it together. We thought we had it together. We thought we understood until we didn't understand.
Mhm.
Yeah. So, and it's okay. It's okay.
It's okay,
Yeah.
but it, it's real. That's all I have
Yeah.
to say. For the most part, there are some very good people in the school district,
Hmm.
but they're overburdened, they're
Yeah.
overworked. But when you step into being an educational practitioner, you have to recognize when you are kind of getting burned out and things are getting perfunctory, and you have to be able to make those personal adjustments, even if it means leaving that job, going to somewhere else, because the harm that you're doing to these children is lifelong for them. While
But you know, Lisa.
you may be inconvenienced with multiple IEP meetings in a week, but you're adversely impacting a child's life for the rest of his life when you
But
walk
you
away and abandon and fail to implement an IEP.
But Lisa, I will say this, and I've experienced this more and more, and it's been worse after the pandemic. I do believe that most of the people that are in the special education field are not skilled. They are not properly trained. And I think
Yes.
again, they are overwhelmed and they're not properly trained. They're just thrown in these positions and
To
you
check
know,
a box.
yeah, to check a
School
box.
district is checking a box. Uh,
Yeah.
and I continue to say that, when you abandon your responsibility, you're affecting a child for the rest of their life. And
And the
that to
parent.
me, that to
And
me is
the parent, because when you send my child out, whether it's from the diploma route or the certificate route, and you tell me my child has met those standards, when if that child comes out and they say they're going to post-secondary education and they have not, that's going to be a hardship on them. And then say that they're going the certificate route and they come out of school, they are forever going to be something on me, and I'm the one that's going to have to deal with what they have not done or what you say they've done, and people don't understand that. So when you taking it, and I met with a teacher, and she told me, she said, I don't take it personal when a parent is upset with me. She said, I take it like, listen, they want the best for their child. And she said, so I don't look at it like they're coming at me. They're coming at the school system. She said, and I'm a part of the school system. So I think that's so important.
yes. And so what I will say is that what I will say is that I think advocating for your child is one of the most important things you can do as a parent. And you have to be unapologetic,
Hmm.
professional. You have to be learned. You have to know what you're talking about
Yeah.
because they're not there to help you in
No.
this journey. I'm not going to conclude that they're there to hurt you, but they're not there to help you. And I just,
Especially if they don't know.
yeah,
Yeah.
exactly. And I just think that there's so many ways to just reimagine special education and to bring the parents in to make them a meaningful part of the team as the law outlines. But until we get there, until we can get leadership in a school, in our school district, until we can get leadership that appreciates this landmark decision and commits to applying it on a daily basis, then we're going to continue to have this rally mindset, you know. So I know we're wrapping up. I just want to say that
Mm.
one of the things that this landmark legislation did is it really clarified the interpretation of FAPE, which is a free and appropriate public education. And that means providing education that is free and tailored, there's that word, to meet the individual needs, ensuring meaningful educational progress. And so then they went deeper on the meaningful progress requirement. Education must go beyond the minimal progress and aim for appropriately ambitious goals based on each child's situation. And then it clarified, in closing, it clarified the educational benefit standard from Rowley, which we talked about. I'm so glad we learned today about these two
Yes.
cases. So we're going to hear them and see them quite a bit more. But it rejected minimum progress. The minimal progress standard was deemed insufficient for students with disabilities for educational growth. It was rejected flat out by the justices. And so meaningful advancement is required. Educational programs must enable meaningful advancement tailored to meet the individual needs. And so if we can get there, the implications and changes that should be happening is so there should be a greater focus on meaningful progress, proactive educational planning, and tailored support and resources, so that these children can have an opportunity to make, that meaningful educational progress. So while, we have a little bit more to discuss, but I think we did a good job of really talking about this and putting a face to
Yeah.
Endrews instead of just using the Endrews decision of 2017. We really got inside of it so parents can understand that this decision was made to empower
Yeah.
parental input and also tell the school districts, not ask, demand, instruct the school districts to understand that de minimis is no more. And so the goal should be ambitious enough to promote meaningful educational advancement.
This was
So
great. I learned a
it
lot.
was good. Well,
I
now
did.
you know Rowley, the
Yeah.
Rowley, decision, which is
And,
what
and
really it was the framework that schools
yeah.
have worked on for 30 some years. But
Hmm.
now that it's gone. And so
Yeah.
now how do we change the hearts and minds of the educators? How do we get them to adopt the Andrews decision more so than just checking a box? But how do we get them to bring the Endrews decision alive in every IEP meeting? How do we do that, Paul?
Advocating, advocacy. That's how we get this done, and educating our parents, which is I think the most important thing is educating our parents, educating our parents, educating our parents, educating our parents. And that's what this is all about. Because as much as we give you information, if you won't take the information that we're giving you and you won't apply it to your special needs individuals, then it's null and void. And again, I say if you're just starting off this journey, use what we're giving you from the very beginning. Understand that process because, again, I think Lisa said it and I said it. When we first started out this journey, no one told us any of this. If I had all of this information, Morgan may be so much further along. But guess what? I keep going back to there would be no advocacy because if Morgan was in that perfect world and I got the help that I needed and everything was perfect, I wouldn't feel the need to help anybody else. But the reason why I'm here is because we weren't given the information. The reason why I'm here is because I did not have all the information. And what that did, 20 Morgan is getting ready to graduate from school in May. And I still have not scratched the surface. I still feel like Morgan got a really bum deal. But what I'm going to use is her situation to empower other parents. So believe me, I'm not saying this, I'm not getting rich off of it. I'm not getting a dime from it. Like Lisa said, she's not getting paid, I'm not getting paid. But guess what? We are being as transparent as possible with what we did not know for our special needs individuals so that you don't have to go through this. It shouldn't be advocacy part 2 or advocacy part 10 because
Mhm.
we're giving it to you from the very beginning. If you have any questions, if you have concerns, please come to us. We will help you in whatever capacity. And again, teachers, we're not doing this to beat you up. We're doing this so that we can have a great team, that we all can see these individuals, just like people graduate, a neurotypical person graduates from school, we're rejoicing. Let's rejoice at the fact that our special needs individuals are getting what they need. So
Yes.
again, we're working as a team. That's what we want to do. We want to work as a team. I come with the A, you come with the B, somebody else come with the C. Let's get to
Mhm.
that table. Let's make a full alphabet and let's make sure our individuals get what they need. So again, I appreciate you, Lisa. All this has been awesome. I'm going to definitely read up on those cases. I want to make sure that I know and understand the verbiage used, the information used, because I don't want to come to the table uneducated, and that's the worst thing we can do. You don't want to go in a dealership and buy a car and be uneducated. You don't want to go to the table and buy a house and be uneducated. Why
Right.
should we do this when it comes to our kids' education?
Yeah.
Okay.
All
All
right.
right, guys. Well, thank you so much, Lisa. And we will see you again on our next episode of Advocacy. But we know we're not going to meet next week. So we want to tell everybody happy Thanksgiving. We want you to enjoy that time with your family. And we will see you again the first Thursday in December. Okay.
All
Bye.
righty.
Have a good one.
Take care, Paula.
Okay. Have a good one, Lisa.